Good morning, everybody. Good morning, everybody. Good morning, everybody. I wonder if people will take their seats where we are going to begin. Welcome, everybody, to New York Law School, the Center for New York City Law, and our Citylaw Breakfast. These breakfasts, as many of you know, are sponsored generously by first Con Edison. I noticed John Banks is here. I'd like to acknowledge Con Edison. They were our initial sponsor and remained. Verizon also has been a generous sponsor. The Murray Goodgold Foundation, the courtesy of Sally Goodgold, and Greenberg Traurig, courtesy of Ed Wallace. I'd like to acknowledge some of the people that are here today. First, my colleague, Art Leonard. Where's Art? He was honored last night by Legal, who's the founder of Legal and has been a very important person in the gay and lesbian community and the legal community. Also, two people who were honored by with Sloan Public Service Awards, Charles McFall, I don't know if he's here yet, and Wilfredo Lopez. Wilfredo, General Counsel at Department of Health, Mental Health, and all the names have changed, but I've known as the Department of Health. I'd also like to acknowledge Brooklyn District Attorney Joe Hines. Thank you for coming. And also the Buildings Commissioner, Patricia Lancaster, who is laboring very hard on a new building code for the City of New York, and which will make a great deal of difference for the city. Also, on behalf of Michael Cardozo, I want to recognize Michael Stallman, who is a judge and who has ruled against the city most recently. But we love you anyway, and thank you for coming. These breakfasts do bring together lots of people who have an opportunity to discuss important issues, and nothing's more important than the work of the Corporation Counsel's Office, and I welcome all of you who are from the Corporation Counsel's Office here today. Michael Cardozo bears, of course, one of the most illustrious names in the history of New York City's legal community, but he's added very distinguished chapters of his own as a partner at Proskauer Rose, as the president of the Association of the Bar of the City of New York, and now as Corporation Counsel in his fifth year, which makes him, if not the longest running Corporation Counsel over the last several decades, and he surely will be in no time. He's had a very distinguished record there where he's been both a counselor and a litigator. He appears in court as well as counsels agencies and the mayor. His record on a number of issues, tort reform, and on handling some of the more difficult cases, the consent judgments the city had, has been truly distinguished, and we are delighted to welcome Michael Cardozo here for a second term at the microphone at New York Law School.
Thank you very much, Ross. It's really my pleasure to be here again. I looked up when it was that I was last here, and it was just about 4 years ago. I had just become Corporation Counsel, and in looking back, I realized I didn't know what the heck I was talking about. Perhaps the passage of 4 years has given me both perspective and maybe a little first-hand knowledge on what I want to talk about. I could go on for a few days, and I don't think that meets your scheduling demands about all the issues my office deals with, but obviously that's not practical. So I thought what I would do is talk about 3 recurring challenges that we have that I think will be of interest to all of you, and then, of course, if time permits, I'll be happy to answer questions on anything else you want to ask me about. And I'd like to start out by talking about how we select our Supreme Court judges. And I want to start out on that because every challenge that my office has comes down to whether it's going to be solved in a constructive, forward-thinking way comes down, in virtually every instance, to the quality of the judges before whom we appear. And I don't mean, when I say that it means that the judges we appear before have to decide every time before the city. Once in a while, as I know at least one person in the audience would acknowledge, we're wrong. And I think more than one, even though maybe he was wrong on that one. But I think, and I know there are many, many, but not exclusively lawyers in this room, we would all recognize that the quality of judicial decision-making is critical. And before I start, I want to emphasize that when I say this, I do not at all mean to suggest that most judges in the city have something wrong with them. Just the reverse. Most of the judges in the city and the state are hardworking, quality jurists. But we have a problem, a big problem in this state. Let me just start by quickly sketching, for those of you who don't know it, how our Supreme Court justices are selected. To become a Supreme Court judge, you don't run in a primary, unlike judges for surrogate or the civil court. Instead, in each of the 4 districts in the city, Brooklyn and Staten Island are one district, and throughout the rest of the state, there is what's called a judicial convention. And the convention delegates are elected in the primary about a week before the convention. And then the convention delegates nominate the particular candidates who are then voted on at the general election in November. Of course, in a democratic city such as this, as a practical matter, nomination at the judicial convention is virtually a lockstep ensured to election. So let me move to my point. 4 months ago, when I assume everyone in this room voted in the general election, and where most of you, I suspect, a couple of months before that voted in a primary, I assume that if I said to you, do you remember who Michael Bloomberg, Freddie Ferrer, Virginia Fields, Gifford Miller, Bill Thompson are, and who did you vote for, you probably, I dare say, would remember. Now, I don't want to interrupt anyone's breakfast, but I would like you all to do me a favor. Will those of you who can remember the names of 2 judicial candidates for whom you voted, just 2, would you stand up, please? 2. Can you believe it? Think about, this is not a typical audience that we're talking to. We're talking about to a very sophisticated audience. And not a single person in this room can remember the names of 2 candidates they voted for, even though, depending on the borough in which you live, there were from 4 to 10 judicial vacancies on the ballot. And statistics would show that you're not alone, because not only don't people remember who they voted for, the fall-off between the mayoral election and the judicial election is more than half, meaning half the people who went to the ballot didn't even bother to vote for a judge. Why? Well, I think there's 2 interlocking reasons. First, people don't know anything about the candidate. And second, if they did, what is the basis on which voters are supposed to decide? Who's going to be the fairest? They just don't know. But while we can speculate about the reasons, there has been an enormous consequence to the fact of this voter ignorance and the non-participation. And that consequence is that the decision on who are going to be our judges has been left in the hands of a very small number of people, the county political leaders. As one Supreme Court judge, who was ultimately forced to step down, said, he stepped down because of misconduct, quote, "You don't have to know something to be a judge. You have to know somebody. Now, shame on us if this is the way we're going to let our judges be selected. Certainly the politicians to whom we have ceded this authority in too many cases don't give a damn about quality. They don't take into account too often the opinions of the people who might be in a position to express opinions about quality. Last year, for example, 9 of the Brooklyn Supreme and Civil Court candidates who were on the ballot had been found unqualified by most major bar associations. Politicians nominated them anyway. One of those 4 who had been found unqualified was nominated because he was supported by the former Brooklyn County leader. The year before, conversely 2 years ago, a civil court judge was denied nomination to the Supreme Court not because she was not qualified, but because she had previously refused to hire as her court attorney the district leader's daughter. Is this any way to select our judges? And this flawed system that we've been following has consequences far beyond not elevating the best and the brightest. For example, in the last 4 years, thanks to the hard work primarily of one of our guests here today, 3 Supreme Court judges in Brooklyn have been charged with a felony. 2 of them have been convicted, and trial on the other is pending. Another Supreme Court judge, this one in Queens, has recently been recommended for removal for improper judicial conduct. And a number of other Supreme Court justices have been disciplined for improper behavior by the State Commission on Judicial Conduct. And recently, I think to put the icing on the cake, or whatever analogy you want to use, Federal District Judge John Gleeson in Brooklyn declared unconstitutional the judicial convention system I just described. He ruled that given the way convention delegates are selected, in which it's virtually impossible for a maverick candidate to have his or her delegates elected, it was impossible for anyone who was going to run against the machine to have a chance. Hence, the system was unconstitutional, and Judge Gleeson very significantly went on to rule that until and unless the constitutional defects he had found were rectified, all Supreme Court justices had to be selected in an open primary. Ladies and gentlemen, there is a judicial selection crisis in this state. The system has not only been found unconstitutional, but it is producing candidates who are clearly not the most highly qualified. What should be done? Ideally, and I emphasize the word ideally, and I've learned after 4 years that's probably not, unfortunately, the standard we have to at least focus on, not that we shouldn't all focus ultimately on the ideal. Ideally, I believe, as does the mayor, that we should have a merit selection system where judges would be appointed by the chief executive following nomination to him of a limited number of candidates by an independent panel. This is the way Mayor Bloomberg and his immediate predecessors have appointed judges to the family and criminal courts. An independent panel whose members, only a minority of whose members are appointed by the mayor, recommend 3 candidates to the mayor from which he selects 1. And this method, I think, has served the city very well, and is a method similar to the method by which we select judges to the New York Court of Appeals. But to effect a merit selection system for our Supreme Court judges requires a constitutional amendment. And not only will this take at least 3 years to effect, but since I've been trying to do this for more than 30 years, I think it's fair to say that it is by no means certain that we will have a constitutional amendment, at least in my lifetime. And so we're faced with three very stark choices. We can hold out for merit selection, which in recent history and even less recent history suggests may never come. And in the meantime, if Judge Gleeson is affirmed by the Second Circuit, judges will be selected in open primaries. And if Judge Gleeson is reversed by the Second Circuit, we will be stuck with selecting judges by the flawed system I've just described. Or we can try to focus on fixing, poor choice of word, correcting this flawed judicial convention system. And I suggest that that's where our energies should lie. Imagine if we had to follow the prescription of Judge Gleeson, an open primary. Will you vote for candidate A because she says she will be fairer than her opponent? Will candidate B be able to raise more money than candidate A and by his television ads explain why he would be a better judge? Will those ads say, I'll decide for tenants where there are more voters, or I'll be the lock-em-up judge? I certainly hope not. We all know that the independence and fairness of our judiciary depends upon judges having an open mind. And think about who's going to contribute to these judicial campaigns. I suspect, and I think history shows, that the people who would make the contributions are the very lawyers who will ultimately appear before the victorious candidate. And that, I suggest, will not engender a great deal of confidence that the judge will be deciding the matter on the merits. So if we can't have a merit selection system, at least in the near term, and if primaries are as poor a solution as I suggest that they are, the only other alternative that I can come up with is to correct the flaws that Judge Gleeson pointed out, that District Attorney Hines has revealed, and that the poor quality that has come too often from the conventions has highlighted. And the mayor and I suggest, and we will be soon introducing legislation that will reflect, state legislation that would reflect, to try to correct the flaws in the convention system. First, we must take steps to ensure that the candidates nominated by the convention are those most highly qualified. And I think we can make a major step towards doing this by having the legislature enact a law requiring an independent judicial qualification committee to tell the convention who the three most qualified candidates for every vacant slot are, and for incumbent judges, if they have been found qualified, in the discretion of the committee, to only suggest the incumbent be renominated. And we can spend lots of time, if there was time, debating exactly the details of how that independent qualification committee would work. It's consistent with the recommendations of Judge Kaye, the recommendations of the Farrar Commission, and I think it can be effected legislatively. Second, we have to deal with Judge Gleeson's determination that the present judicial convention system is unconstitutional because it is so difficult for candidates to oppose the party regulars. And I think this problem also can be solved, and it's highly technical, by passing a law reducing both the signature requirements for convention delegates and the number of delegates in a judicial convention. I believe this would meet the constitutional problems outlined by Judge Gleeson. Now, there's one more solution, of course, that could be effected while all of this legislative effort is going on. The political parties could try to reform themselves. They can pass internal rules creating independent screening panels, and providing that they will only nominate those found qualified by the panels. Unfortunately, recent experience offers ample proof why we should not wait for the parties to correct the problem, and why we must move forward with a legislative solution now. We can't afford to wait any longer to reform the system. With every additional scandal, the public loses more faith in our judiciary, and the rule of law is more and more threatened. And equally important, the results of the efforts of the district attorney, the problems that we have found in quality, and Judge Gleason's ruling have created a long overdue momentum to effect real change in the area of judicial selection. The mayor, and I hope many others, will be leading the charge, and I hope as many of you who can will join us. Let me move to two other challenges, more specific challenges now, that my office deals with. And the first, as Ross alluded to, is in the area of consent decrees. And I particularly think that this is an appropriate place to talk about consent decrees, since our moderator, Professor Sandler, has made such a major scholarly contribution to the debate on this subject in his book, Democracy by Decree. When I stood here 4 years ago, we had outstanding orders against New York City that said, among other things, these were orders that directed the city have 75-watt bulbs in the prison cells or be in contempt of court, have beds in the prison 6 feet apart or be in contempt of court, serve Pedialyte, a medicine or formula, to infant children in homeless shelters or be in contempt of court, and for certain special education personnel, you must supply them with a photocopier, $150 for supplies, a filing cabinet, and access to a telephone line. If you don't do that, these orders said, you're in contempt. These are not rulings or directives of a commissioner. These are directives of either a state court judge or a federal court judge. Now, these orders, and there are literally thousands of them, trace their origin to court orders, usually consent decrees, that dated back in many, many instances to the late 1970s or early 80s. Those cases which resulted in these consent decrees came about because the complaint alleged, and I am told perhaps correctly in many instances, that the city had acted improperly, that the prison conditions had become intolerable, that the city had not provided adequate shelter to the homeless, or that the city had violated federal law relating to special education. When I stood here 4 years ago, I said that I would do my best to prevent the city from having to enter into court orders like that in the future. Now, this issue is of major significance. What do you do when the government is accused of misconduct, particularly if it turns out upon examination? Of course, it doesn't happen in this administration, but in the past, that something in fact has gone wrong. Obviously, people have a right to go to court, and judges have an obligation to do something when the city does something wrong, the government does something wrong. At the same time, we don't want to tie the hands of future mayors and commissioners, and we don't want to enter into force the judges to enter into the kinds of micromanagement orders, the operational decisions of the kinds I described. So what have we done? In one area, the best way to deal with it, obviously, is not to do anything wrong. And certainly, I think it's fair to say that Mayor Bloomberg and the commissioners, including the one who's in this room, have done Herculean efforts to be sure that we comply with the law. And I believe that it's my job and the job of my office, when we hear of a potential lawsuit, to do everything possible to try to solve the problem before it becomes a litigation. Now, that doesn't mean that we capitulate every time an advocacy group or good government group says you're doing something wrong, because I think in most instances they're wrong. And if they're wrong and they insist upon suing us, we litigate, and we litigate aggressively. But unfortunately, as we all know, there are times when the city has done something wrong. It can't resolve the lawsuit, and something has to be done to resolve it. And when we do have to resolve it and have to enter into an agreement, we have to focus on the fact that we have to limit the agreements that settle these lawsuits, both in terms of substance and in terms of time. We can't enter into agreements that control us in virtual perpetuity. There are agreements to which New York City is a party that were entered into by the Corporation Counsel appointed by Mayor Beam. I don't say that to criticize him. I'm simply making an observation that it is really rather incredible that we are still ruled by agreements that Mayor Beam entered into. And at the same time, we can't allow any agreement that ends one of these kinds of cases to result in the kinds of micromanagement that I was talking about before. So let me just highlight one recent settlement that we entered into that I think highlights the potential alternative, assuming we have to enter into these agreements at all. In early 2002, a case began alleging substantial violence throughout the New York City prison system. We denied the allegations, vigorous discovery, and the case was scheduled to go to trial before Judge Chin a few months ago in the Southern District. And we settled the case. But rather than entering into the consent decree that I just described, instead what we did was we entered into a private contract with the plaintiff's lawyers in which we agreed that over time the city would take certain action, particularly in the area of installing cameras in the prisons, that would alleviate the problem that the complaint had highlighted. The federal case was dismissed, and if we don't do, and we are confident we will do, but if we don't do what we promised to do, the plaintiff's remedy is not to go back to federal court and have the court start micromanaging the agency. The plaintiff's remedy is to start a breach of contract suit in state court. And at the same time, the agreement specifies that its termination date coincides with the end of Mayor Bloomberg's term. And I think that this suggests a constructive model for dealing with problems like this in the future. Time precludes me from going on into this area. I will say that we have made vigorous efforts, I think in some very successful, to end many of the consent decrees that I alluded to. I just want to highlight one other area of focus of my office that I think may be of interest to all of you, and that's in the area of torts. 4 years ago when I stood here, city tort payouts for the preceding fiscal year had totaled $556 million, and we had 48,000 pending tort cases. Now, $556 million translates into the salaries of 8,500 firefighters. Half of $556 million translates into the salaries of 8,500 firefighters. Think of what we could do if we could simply cut that tort payout in half. and think of what might happen if we could reduce the volume of our tort cases to a more manageable number. I'm pleased to report, after 4 years, and given the substantial help and cooperation that we have with the Comptroller's Office, we have made major progress, primarily, I think, as a result of looking at tort cases in a different way. As of June 2005, our pending tort caseload is down 30% to 33,000 cases compared to 48,000 cases 4 years ago. Now, this does not mean that we settle every time someone sues us. And I think the proof of that is that while our pending caseload has decreased in the 30% range, our payouts have also decreased. In the same period, our tort payments, which had been $556 million, have declined to $489 million, a 12% decrease. Too much money, no doubt, but I think we've made some major strides. We could do a lot more with the help of the New York State Legislature. That's not an easy lift, and I was in Albany a few weeks ago lobbying for that, and we will continue to do our best. There's one major area in the legislative frame of torts that we have made progress. We persuaded the City Council a few years ago to pass the so-called sidewalk bill, which means that today, instead of the city being liable every time someone slips and falls on the sidewalk, that the adjoining landowner is responsible, except in the case of residential 1, 2, and 3 family homes. And the effect is that our sidewalk cases have plummeted, and when the bill is in full force, we should be saving, because of that one legislative change alone, about $40 million. So, consent decrees, a big continuing challenge. Torts, a huge economic challenge to all of us. Take another issue or issues, be they gun control, yesterday's decision in the education area, our efforts to limit adult use establishments to appropriate areas, environmental cases where we are both plaintiffs and, in some of the cases, defendants in others, the TWU strike. I could go on and on. These are the issues that we deal with, and they all come back to one thing. They all end up before judges. It highlights why we need to have the best quality people on the bench. It is really a pleasure to deal with these challenges, and it's why, hopefully, in this 30 minutes or so that I've talked, you can understand why I continue to believe that as the Corporation Counsel of this city, I have the greatest job any lawyer could ever have. Thank you very much.
That was a very full description of some important issues, and I hope that we have some good questions. The microphones are here. Please come up, and you can line up, and that way the questions will go more quickly. While people are going up, let me just ask, do you have any comment on the Taylor Law litigation?
The press asked me that question yesterday, and my answer was, since the matter is still in litigation, I cannot answer, and I think I said I would probably give that answer today also. I would say that it was a very interesting event to go into Brooklyn Supreme Court at 4 o'clock in the morning to seek the contempt and the injunction. The Taylor Law is obviously highly complex. We have the judge has found the union in contempt of court to the tune of $1 million a day. This union was on strike for roughly 3 days. The union has appealed to the second department primarily on the grounds that it believed it had a right to a jury trial. That appeal has not been scheduled for argument, but that is a highly significant question. The plaintiff in the TWU case is obviously the MTA, not the city. The city has brought its own independent action, which is also pending. And unfortunately, despite the intense interest in this room on the issue, I hope you understand why I think it'd be inappropriate to comment further on it now.
We accept that reluctantly. Next.
Good morning. David Cardozo. I teach New York Affairs at St. John's, and I share your views on the judicial selection and applaud your efforts. Just a question, has there been any discussion about maybe changing the way the city civil court judges are elected to bring that into conformity with the way the criminal and family court judges are, the appointment model?
Well, there has been discussion. It goes back. That would also require a constitutional amendment. We could talk about that for the civil court. You could talk about that upstate for county courts. You could talk about that upstate for family courts where the judges are elected. You could talk about that statewide for surrogates where there are open primaries. And you're back to the same issue. I think right now we have a Supreme Court crisis, and we should focus, not that we don't have problems in the other area, and I think practically the best solution, therefore, is at least at the moment to focus on the Supreme Court issue.
Rosa Parks has a day in New York City, but Rosa Parks' actions were meant in contempt. I quote you from Criminal Court Judge Anthony J. Ferrara, who is a product of the mayor's appointal system. So if you can get judges who sit on the criminal court bench who think that Rosa Parks' actions were criminally contemptuous and who don't like cameras in the court recording them, how can you be so sure that the elected system is going to be better than the meritocracy system?
I think you meant, how can I be so sure the appointive system will be better than the elective system?
I stand corrected.
I think we can all highlight problems in the appointive system just as we can all highlight problems in the elective system. There's no system that is perfect. I do suggest that while the debate on appointment versus election goes forward, I don't think that reasonable people could differ as to the fact that the present judicial convention system, which has, as a practical matter, meant that no one is making the decision, at least in some areas, other than the political leaders, needs to be corrected. And that's why I take the position that I do.
Could we start off by getting Judge Ferraro off the bench?
Good morning. My name is Eli Richland, and I've served as Chief of Staff for City Councilman Eric Joya. Thank you very much for coming out today. In the past year, Councilman Joya has sponsored, and the City Council has overwhelmingly passed several pieces of legislation that would help increase access to food stamps. It's our understanding that right now the city believes these bills are unconstitutional and is not enforcing them. I wanted to ask what your views are, given the recent appellate decision on the Equal Benefits Law, how that decision affects the separation of powers that was outlined between the City Council and the mayoralty under the most recent charter reform.
Well, I think the most recent decision to which the Speaker is referring is that there was an issue. The City Council had passed a law in the area of equal benefits that the mayor had vetoed, believing that it had imposed unconstitutional requirements on the city. And the legal question posed in the case was whether or not, if the City Council passes a law, mayor vetoes, and the City Council overrides the veto, and the mayor believes that the legislation is unconstitutional, who has to sue who in terms of the declaration of the constitutional validity? And the Court of Appeals ruled in favor of the mayor, saying that if the mayor believes the legislation to be unconstitutional, he did not need either to enforce it on the one hand or to sue to have a declaration on the other hand, and that therefore it would be incumbent on the legislative body to bring that lawsuit, and then the court would resolve it. So I think that we obviously believe, since we were the victor in the Court of Appeals, we believe that decision was correct. And I think, as it stands, that is the latest definition of the separation of powers in that area.
Thank you.
Good morning. My name is Stuart Collins. I thank you for being here. We work together on the Election Commission and the Association of the Bar. I've spent about the past 25 years working on elections, and I really feel very frustrated because we're in worse shape now than we were before. As of now, we are not in contempt, but we are in violation of federal rules which permit us to get millions of dollars. We do not have election machines that work. Nobody is too interested in it. And I will tell you that in the year 2000, when I was involved very seriously in the campaign, 200,000 people in New York State were unable to vote. Now, I can tell you how these figures are arrived at. We are doing nothing at all to ensure that people could vote, and I wonder if anyone would be interested in picking up that problem.
Well, Stuart, you make an excellent point. Wearing a different hat, the mayor appointed me in 2004 to chair a task force on the modernization of the election issues. It's a bipartisan group, includes people like former Speaker Peter Vallone on it, and we have dealt initially, and this is, I think, issue number one for everyone in this room and throughout the state, on the absolute outrageous failure of the state of New York to take steps to implement the Help America Vote Act. For those of you not in the know, I suspect that all of you remember the fiasco in Florida that was resulted in the hanging chads and all. And shortly after that debacle, Congress passed legislation mandating modern voting machines and appropriating money to allow states to buy new voting machines. And New York State would have gotten roughly $220 million as a result of that. But what was necessary before that would happen is that the state had to pass certain implementing legislation and then obviously would have to take steps to purchase the new machines. For some reason, the legislature took until June of 2005 to pass the needed legislation. All that legislation did was kick all hard decisions down to the local boards, and the general counsel of the city board, I know, is here today. And perhaps even more outrageously, the governor signed the legislation a few weeks later in early July. The state board had to promulgate regulations to implement that legislation. Legislation signed in July. We have to have machines in place under federal law by September 2006. It is now March 2006, and the State Board of Elections has yet to promulgate the regulations. And to buy new voting machines is not like going down and buying a bottle of aspirin at Duane Reade. For New York City, it means the purchase of over 7,000 new machines, highly technological challenges, and the State Board has done absolutely nothing. It is an absolute scandal. The mayor and the task force, I think it's fair to say, have been very outspoken on this. There is now, as Stuart said, a federal lawsuit. We're the last state in the union to have done this. The Justice Department has sued the state and the Board of Elections. And yesterday, in fact, the state entered into one of those consent decrees in which it agreed, and boy, the devil is going to be in the details, the state agreed that in 10 days it will submit a, quote, plan, unquote, to comply with the federal law. As a practical matter, New York State will be in violation of federal law come November. It is impossible now to have those machines in place. The efforts are now to try to deal with this, at least for the disabled community. Even that, unfortunately, because of the passage of time, may be in large measure impossible. We can't allow a situation where a well-meaning federal statute being implemented will result in even more chaos come November. But you're absolutely right, and we have to keep focusing on it. It is an absolute outrage.
Thank you.
Thank you. My name is Michael Gruen. I'm an attorney practicing in the city. You made the interesting observation that the city has saved, I think, $40 million by transferring liability from the city to adjacent private property owners for slips and falls on sidewalks. What I wonder is whether you have any thoughts on the fairness of that transfer from the property owner's point of view, and also whether the result might not be simply that the $40 million moves to another pocket, namely the owner, or even more than $40 million.
I think it's a very good question. We had a lengthy discussion with representatives of the landlords on that as the bill went through its legislative passage. And let me give you a couple of answers to that, because I think bottom line my answer is no to what you're asking. First of all, most for major commercial and residential buildings, this was covered under their insurance anyway, as a practical matter. So that I don't think that this cost was being passed on disproportionately. Second, the amount of sidewalks in New York City is literally, if you put all the sidewalks together, half the circumference of the globe. And I mean that in most literally. It is therefore absolutely impossible for the city of New York to fix every crack in every sidewalk under the pain of liability. It won't happen. The result, people slip, fall, collect. It also means that we have dangerous sidewalks. And one of the ironies of the old law is the only time the landlord would be liable for a sidewalk fall if he was dumb enough to try to fix the sidewalk himself and didn't do it correctly, or if he was dumb enough not to shovel the ice off of the sidewalk and someone slipped. So now what we have is a economic incentive and practical incentive on the landlord to fix the sidewalk. I don't know how you would prove this, so I can only tell you this anecdotally. I believe the result is that the sidewalks, because the landlords are doing it on their individual buildings, are doing it faster and more efficiently than the city would do it, because the city couldn't do it. And if, in fact, there is some modest cost being passed on to the homeowner, rather than to the general public, I don't think that one would say that that is an improper change of who should be paying the cost here. If you live or work in front of a commercial building or a big residential building, and as a result your insurance costs have to go up slightly, I would suggest, and I don't think this has been the economic impact, but if it is, I think the people who live and benefit from having a working sidewalk are the ones who would pay for it more equitably than the entire city.
Good morning. David Bloomfield, Brooklyn College. Some education questions. First, which side is going to appeal yesterday's CFP decision? Second, can you comment on the status of the Jose P. consent decree? And third, with mayoral control of the Department of Education, how can the city be arguing with a straight face that the city council is preempted from legislating in that area?
Three excellent questions. Question one, which side is going to appeal? Yes. It is a very, very interesting opinion. I thought the New York Times this morning captured the differing views of it quite accurately, as it said that Bruno Pataki and Silverall claim victory. which means somebody may be doing something right. For those of you, and it's a very long, complicated opinion, and as the mayor said, we're still studying it, and I want to emphasize the city is only amicus in the case. The city is not a party to the case. But basically, the three-judge majority in the appellate division said that the legislature on the operating expense side should consider appropriating somewhere between $4.7 and $5.3 billion to New York City, and shall appropriate that amount, or I'm paraphrasing it. And the lawyers in this room can have an interesting discussion among themselves as to what that means. It also said that the legislature shall implement a capital plan to the tune of $9.1 billion. The two dissenting judges said the order was not specific enough, and I think we have to wait and see what happens next as intense budget discussions go on over the next week or so in Albany. The second question, the Jose P. Jose P. is the special education case that I referred to, in which a decree was entered by the late Judge Nickerson in Brooklyn in the late 1970s. That's one of the decrees to which the city is still a party. The city has recently advised the court, the case has now been reassigned to Judge Corman, I forget the magistrate in charge, that it will be moving to vacate the entire Jose P. decree. In the meantime, obviously discussions are going on to see if that can be done on an amicable basis, and so that's really where we are on Jose P. In the third area that you asked about whether, now that the mayor has control of the Department of Education, why is the City Council nevertheless preempted? I think if you go and you look at the statute, while the mayor does now have the power to appoint both the chancellor and a majority of the council that advises him, the legislation makes clear that the Department of Education is still considered to be a school district, and therefore, just like other school districts throughout the state, it is therefore subject to the Board of Regents and other state control, and that therefore most city council legislation in the area would be inappropriate.
Good morning. Dirk Olin with the Institute for Judicial Studies. I'm independent of your very interesting and arguably laudable proposals on judicial selection. I'm curious as to in any scheme and avowing your point that most judges are fair and competent under any selection system. What is your take on the statutory and fiscal foundation and the practical effect on a day-to-day basis of the Commission on Judicial Conduct?
Well, the Commission on Judicial Conduct is a constitutionally and then statutorily created commission of, I think it's 13 people, with various people appointed by the majority, minority leader, chief judge, and so forth, with authority over judges ranging from town court judges all the way to the highest court. I certainly do not claim to be an expert as to whether their actions have over the years been correct, appropriate, aggressive enough, too aggressive enough. There's some interesting cases that are being played out in the courts right now on that. One of the judges to whom I referred has challenged the recommendation of removal, but I don't feel really qualified to pass judgment on that.
And Charles Sines, the District Attorney of Kings County, and I don't have a question for Mike. I have an observation for this audience, who I know. If I stood in front of a voting booth, you'd knock me over. And I wouldn't ask the question that Mike asked, can you name two people for whom you voted who were for judicial office? I'd ask the question, do you know you're disenfranchised? Not just by a convicted felon like Clarence Norman, Jr., who's been convicted of multiple felonies in Brooklyn, but by good and decent people who are county chairs in the other parts of the 12 judicial districts. They select the judge for you. And that's wrong, and you can't allow that to happen. We're in an election year. What the Corporation Counsel and urged on by the mayor has proposed in all the studies I've had with this, and clearly I'd like to have an appointive system. But what he's proposed makes perfect sense. But it will not be passed because there is no interest in the legislative leadership. So this is the year the Assembly's up for re-election, the Senate is up for re-election. This is the year for you to say to someone who is either an incumbent or is running, how do you stand on the mayor's proposal to have an independent screening committee? How can you be against it and take away my right to vote? So if you've ever confronted a legislative leader before, you've got to really put the issue where it belongs, and that is we cannot allow a state of affairs that continues to disenfranchise us as voters in this state. Thank you.
I agree.
On that note of agreement, we're going to bring this breakfast to a close. I want to thank Michael Cardozo for a really stimulating and important talk. As we always do at these breakfasts, we'd like to give the speaker a product of the scholarship of this law school, and knowing of your interest in history and of the history of the legal profession, I'd like to present to you a book by my colleague William LaPiana, Logic and Experience, The Origin of the Modern American Legal Education System. Thank you so much for a very stimulating and wonderful talk. You'll love this book.
Great, thank you.